Is abortion a right or a privilege? Well, truthfully, there's a little irony in the matter. Abortion. It's a societal hot-button issue, but at the end of the day, it's a personal matter, a private one on multiple counts. So then should it be a social matter? And where does the right to privacy come from? We almost need to dig deeper on the second question in order to consider the first.
It has to be some form of punishment.
For the woman?
Yeah, it has to be some form.
We've had 8 debates before. This is our 9th. We've not had one question about a woman's right to make her own decisions about reproductive health care.
During the next couple of minutes, we won't be talking about the right to life or the right to choose. We won't be talking about murdering the unborn or a woman's right to control her own body. As much as this sort of language and these claims fuel the abortion debate, they are not really central to the way the Supreme Court has addressed the issue of abortion. With the Supreme Court, abortion is about a privacy right and a liberty claim, protected by the First, Third, Fourth, Fifth, and Ninth Amendments. The origins of an implied right to privacy date back to Supreme Court cases from the late 19th century. In 1890, Louis Brandeis, who was later named a justice to the Supreme Court, defined this right of privacy as the right to be let alone. In the 1923 case of Meyer v. Nebraska, the court ruled on a Nebraska law that forbade children younger than high school age to be taught a foreign language. It triggered conversation about areas of individual life where the government could not tread, thus further connecting privacy and liberty as implicit protections of the Bill of Rights and 14th Amendment. From the 14th Amendment, we infer that liberty means more than freedom of movement or even thought. It's freedom from bodily restraints and the right of the individual to contract, engage in occupations, marry, establish a home, have children, worship any god, and generally enjoy those privileges long recognized at common law as essential to the individual's pursuit of happiness. If the right to privacy implies all these things, then a woman's right to an abortion, which affects her own body, is also a private matter that the Supreme Court begins to explore with its Roe v. Wade ruling in 1973, which extended privacy to a woman's right to have an abortion. Since then, the term undue burden is frequently thrown around in conversations surrounding abortion. But what does it actually mean? After the 1992 Planned Parenthood v. Casey court case, the state was allowed to regulate abortion in the first trimester so long as the regulation didn't pose an undue burden on a woman's fundamental right to an abortion. Due to the fact that many view abortion as a privilege and not as basic health care, the question of who has access to this privilege has been controversial. The Hyde Amendment of 1976 blocked federal Medicaid funding for abortion with the exception of rape, incest, or threats to the woman's life. While 15 states cover abortions with state funds, the majority of states don't, making abortion a privilege for those who can afford it.